So this one is going to be a very short one because you've already done the breach of contract from the first video. So you can refer to the other video. So let's do the contract. The first one would be what a contract is. So a contract is a legally enforceable agreement between two or more parties that creates an obligation to do or not to do certain things. So you can already see from the definition that it is an enforceable agreement. If it's not enforceable, then it's not a contract. Between two or more people, what that means is that you cannot contract to yourself alone. It has to be more than one person, which is two or more people. That creates an obligation. It creates an obligation. You have to do something, to do or not to do certain things. So it is a formal, written, or verbal arrangement. So you see, I made an emphasis on these three elements: formal, written, or verbal. So it doesn't have to be in writing only. It can still be a verbal agreement and it's still a valid contract. Okay. So formal, written, and verbal agreement arrangement that outlines the terms and conditions that the parties involved have agreed upon. So a valid contract typically involves an offer and acceptance. What that means is that I have to offer something and then the other party has to accept. Then now there is a meeting of the minds where I have offered and she has accepted, and now we have an agreement, consideration, and an intention to create legal relations. And it can be enforced through the law. If one of the parties fail to fulfill their obligations. So now let's look at the requirements of a valid contract, which is the last slide, obviously. Then we're going to try and break it down a little bit so that you can be able to understand what these requirements entail. And so that you can, even if you didn't remember the name, but you can still remember what those requirements entail. So depending on obviously the mark allocation, if you exhibit knowledge of what that you do understand what consensus is, because an exam is something very tricky, that sometimes you forget the actual name for consensus, and then if you remember what consensus is, then you can actually write the description of it, and then the lecturer will obviously see that you have a knowledge and an understanding of what you're writing about. You just possibly forgot the name. So consensus is when there's a meeting of the minds. Okay, by meeting of the minds, I mean, for example, let's say person A, which is myself, and then person B. So I have an offer. I'm offering person A a horse. I'm selling person A a horse. So person A is like, person A wants to buy a horse from me, but it should be some kind of a mutual agreement or understanding that person B knows that he is buying a horse from me. So we have to our minds need to align. Okay. So in a case where there is no consensus is when I said, I'm selling a horse to you, Mr. B. And then Mr. B in his head, he's like, oh, he's selling a donkey. You understand? So there is no meeting of the minds. Our minds do not align. We don't have a common ground of understanding, because as A, I know I'm selling a horse, and then as B, he sincerely believes that he's probably buying a donkey, and then when it's delivered, it's a horse. So there is no meeting of the minds. So if that does happen, then it means that there was no consensus, and then contract is no longer valid. Okay, perfect. I have already explained the offer and acceptance, that someone has to offer something and the other party has to accept. So that's typically the offer and acceptance element there. And then let's move over to the lawfulness. So with regards to the lawfulness, let's say, for example, you cannot put something unlawful in a contractual clause and then you say that your contract is going to be lawful. So let's say, for example, there was a case a couple of years ago. It's called Kylie versus CCMA. So Kylie was a prostitute, but she used to work for this brothel in Cape Town. And there was a time when, during the course of their employment relationship, where they had a dispute. Kylie had a dispute with her boss. And then her boss was like, you don't really work for me anyway. You're not my employee. But they had a contract, right? And then when the court looked at all the elements of the contract, everything else was fine, except the fact that Kylie was a prostitute. And that was the unlawfulness part that kind of voided the entire thing. Although the court looked at the entire scenario objectively and saw that by the purposes of the law, Kylie was an employee for that particular company, but nonetheless, that lawfulness part, that she performed prostitution, which is illegal in the country, so it makes the entire agreement invalid. So, or in that particular decision, although the court did determine that, okay, the contract should have been valid, but now they're not going to give her a relief or a remedy, just for the purposes of the law, to say, okay, if we remedy her, and then we're going to have a whole lot of people coming here looking for the same remedy. So you cannot insert an unlawful clause in a contract and expect it to be validated. It will invalidate it immediately. Okay, now let's move on to the issue of capacity, which is the legal capacity. For example, you cannot contract with a 7-year-old. They don't know nothing. They do not understand the terms and conditions of the contract. They do not have the right capacity, the legal capacity to litigate, to understand the complex terms, and so on. So you cannot contract with a child. And then possibility, it must be physically or possible rather to perform the terms of the contract. Let's say, for example, okay, I contract with you. I said, okay, fine, I'm going to build a house for you, and then come to your place the following day with my tools and everything, and you're like, oh no, on the contract actually meant that you're gonna have to build my house in the moon. And then that renders it impossible, you understand? So it has to be possible to be able to perform the duties and the responsibilities as stated on that contract of employment. So just to recap, the requirements of a valid contract consists of an acceptance, lawfulness, capacity, and possibility. And then your definition of a contract: it is a legally enforceable agreement between two or more parties that creates an obligation to do or not to do certain things. So I would stick with that definition because it perfectly fits the definition of a contract. Or else you can choose and say, okay, fine, I can use the second one, or in addition to this one, I can use the second part that says it is a formal written or verbal arrangement that outlines the terms and conditions that the parties involved have agreed upon. You can obviously use that as a supplement, but it's entirely up to you. I would go with the first one depending on the mark allocation, but if there's a lot of marks, obviously I'll go wild and crazy and include everything, including the requirements plus the explanations. Don't forget the explanations. Okay, thank you.